does call the case. The People versus, right on the annual, is it Burnt House?
Gotta be silent.
The courtroom opens with what seems like a routine procedural hearing, but don't let the calm tone fool you. Beneath this quiet start is a case loaded with heavy allegations, serious legal stakes, and a judge who will soon have to balance public safety against the rights of a defendant who has already posted a massive bond. And that's where things get complicated. A $50,000 cash bond isn't pocket change. When someone's family puts up that kind of money, it usually signals two things. First, the charges are serious, and second, the family is betting heavily that the defendant will return to court. But today's hearing isn't about guilt or innocence. It's about where the defendant is allowed to live while awaiting trial. And surprisingly, that question can become one of the most heated debates in a criminal case. The defense is about to argue that their client simply has nowhere to go. He can't return home because the alleged victim lives there, and he claims his only support system is in another state, Ohio. Meanwhile, prosecutors are preparing to raise concerns about safety, potential risk, and disturbing allegations tied to the case itself. So the judge now faces a tricky situation. Do you allow someone accused of a serious crime to leave the state, or do you keep them nearby where the court can monitor them more easily? And here's something to think about as we watch this unfold. If someone posts a large bond and promises to return, should they be trusted to relocate, or is that simply too risky? Let's see how the arguments play out.
Stephanie Cannon on behalf of the Sprint House. Sorry, did you want to do it? Okay.
No, she did not. You're so rude. Go ahead, Ms. Cannon.
Please state your name for the record.
Daniel Barhouse.
Thank you. Cannon, this is your motion.
It is my motion, Your Honor.
Go ahead.
Your Honor, my client, this is a motion to amend the bond condition to allow him to live in Ohio with his brother. There are no minor children present. My client was able to bond out. He paid a substantial bond of $50,000 cash. Based on the allegations in this case, he cannot return home as the complaining witness lives there. Outside of that household, he has no family. He has no other people here. It's that all of his family lives in Ohio. My client, when he was released, he was told he couldn't go to Ohio. He immediately called me. We set it up so that he had provisions here. However, he is not a rich man. He can't continue to pay hotel costs and motel costs. He simply wants to be allowed to go to live with his brother in Ohio. He will come back for court when required. He is here today. He is not a flight risk. The 50,000, his family is not rich. So that 50,000, if he were to abscond, would be a major loss for his family who put up the monies for that bond, Your Honor. My client is just simply asking not to be made homeless, and because he has nowhere to go. He just doesn't have anything else outside of his family. So he's just simply asking to be able to reside in Ohio, and he'll come to court when the court asks. He's here today. He'll be here whenever the court requires him to be here.
The defense attorney here is framing the situation in a very specific way, not as a legal maneuver, but as a humanitarian request. Notice the language, not to be made homeless. That phrase is intentional. Defense attorneys often try to shift the narrative away from the charges themselves and toward practical realities facing their client. From a legal perspective, this type of motion is called a bond condition modification. Essentially, the defendant is asking the court to change the rules tied to his release. Normally, those conditions restrict travel or require someone to stay within a certain jurisdiction. Changing them isn't impossible, but it does require the judge to feel confident that the defendant will still return for court. And the defense is leaning heavily on one key argument: the $50,000 cash bond. When families put up that kind of money, it creates a powerful incentive for a defendant to show up. If he disappears, that money is gone forever. Courts often consider that financial pressure when evaluating flight risk. But here's where it gets tricky. The nature of the allegations can change everything. Even if someone posts a high bond, judges still have to consider public safety and victim protection. So the big question forming in this courtroom right now is this: is this truly a case of someone needing family support in another state, or is allowing that move potentially creating a bigger risk for the court and the alleged victims?
Sponsoring people.
Your Honor, ultimately, I'm going to leave it to the court's discretion. I do want to say a few things. I don't feel this is an emergency situation. I understand that that's the perspective of defense and defendant. However, defendant being unable to return to a residence where he sexually assaulted his own daughter, quite frankly, is not an emergency. With that said, like I said, I'm going to leave course discretion. I am concerned that he's out. I am concerned, especially given that there has been statements made by the victim and the mother of the victim that they are in great fear of this defendant. Also knowing that when police went to interview him, he asked if he could go back into the residence to grab something. They escorted him into that residence and found that there was a gun sitting out on the couch. So what he was going to do or not, we don't know. Luckily, nothing happened. But there are a lot of concerns. I understand that $50,000 is a high bond. Obviously, he's posted it and we are where we are. I do have great concerns. We're in a tough situation because on the one hand, the further away he is, the better. On the other hand, I'm not sure what will happen if he decides to take off. I'll essentially just leave it to the court's wisdom and experience in handling these things. I just want to put those concerns on the record. If he's allowed to go to Ohio, I'd ask for home confinement. I want to make sure we are also have bond conditions in place for no contact with any minor children. I would like to also know that the residence in Ohio is nowhere near school or daycares or anything like that. So for me, quite frankly, it's a little premature. Again, I don't see it being an emergency in that sense. I think it certainly need some more information. If that can be provided, I'd happily look at it. Those are some of my concerns.
Thank you. Your Honor, as far as the weapon in his house, at that point, he was lawfully owning the weapon. It was his house, having a gun in the house. I don't know how that reflects on whether or not he will return to court or abscond from the court in any way, shape, or form. My client is simply asking not to be made homeless. The brothers in question are present. They are here. They live without children in the home. He has no problem not being around children. And
what major city is Plymouth, Ohio near?
I'm sorry, what is what?
Well, what major city is?
Mansfield is
Mansfield is the.
Mansfield, Ohio, yes, Your Honor.
Okay. And you're currently on a tether?
No, sir.
No, Your Honor, it was 50,000 cash. You didn't put a tether provision in it. It was, he just.
I didn't. You mean the court did?
The court did not, Your Honor. And again, he's here, so he's been out. Back. He's not trying to abscond. He wants to handle this case the right way.
Are there schools located in the area? Right around that?
No, not close to where they live at, no.
When you say not close to, what's that mean?
They're probably about a mile away.
That's close.
And Your Honor, yes, our people's position is that is too close. We'd also like to have an exact address so we can confirm that. I understand that's coming from defendant's brother.
It's actually in the motion. I wasn't just putting it on the record.
Your Honor, I mean, even if he were to stay here, no matter where he's at, he's going to be within a couple of miles. Or I mean, if he were in his home, he's going to.
Right, but so first of all, I've got a number of different problems. One is he posted, there's no tether.
Now we're entering the technical side of pretrial supervision, and the judge has just discovered something that clearly surprises him. The defendant isn't currently on a tether. A tether or electronic monitoring device is essentially the court's digital leash. It tracks where a defendant is at all times and alerts authorities if they leave a designated area. In many serious cases, it's standard practice when someone is released on bond. So when the judge realizes there's no tether in place, the entire situation shifts. Suddenly, the court has less oversight than expected. That's why you hear the judge say he's starting from a different position. In other words, the risk calculation has changed. Now the conversation moves toward a compromise. Instead of simply denying the request or granting it freely, the judge is exploring controlled relocation. That means the defendant could move to Ohio, but only under strict monitoring conditions.
Okay, so I'm starting from a whole different position than where I thought I might be starting. He's not tethered, but in order for him certainly to go to Ohio, Well, irrespective of whether he goes to Ohio, he's going to be on a tether. He's got to report to community corrections for a tether.
Your Honor, when I attempted to stipulate to this, not with sister counsel, but with another attorney, I said he will even tether to the house. He had no problem with that.
Tether to which house?
To be on his brother's house is the only house he can go to. So that was indicated.
No, I'm not saying that there's anything bad about it. I'm just saying he's going to get a tether. The question becomes then, and is what's he planning on doing while he's there? Is he going to be working, or is it just that he needs to be around family at that point?
Well, Your Honor, he is a disabled vet with PTSD, anxiety, and various things. So usually his family would actually come stay with him. So they would drive up from Ohio and actually stay with him. So no, because of his disability and everything, he is not working right now.
Okay. So here's what I need. So what I'm going to order is a home confinement tether.
And there it is. The judge delivers the ruling that reshapes the defendant's freedom moving forward. Instead of denying the request outright, the court allows him to relocate to Ohio, but under one of the strictest forms of pretrial supervision short of jail, home confinement tether. That means the defendant's movements will be extremely limited. Home confinement typically requires the person to remain inside their residence at all times unless the court specifically approves travel, usually only for court appearances, legal appointments, or medical needs. Every step outside that boundary triggers an alert in the monitoring system. The judge also adds another layer of protection by restricting the defendant from being within 2,000 feet of schools or educational institutions. These kinds of conditions are very common in cases involving alleged crimes against minors. They're designed not as punishment, but as preventative safeguards while the legal process unfolds. But this ruling raises an interesting question about modern pretrial justice. With technology like GPS monitoring, courts now have tools that allow defendants to remain free while still being closely supervised. So here's something worth considering. Do systems like electronic tethering strike the right balance between freedom and safety? Or do they still leave too much room for risk?
Okay.
Okay.
I will. So he has to be tethered prior to leaving the state. I will let him reside in Ohio at that address. I will also indicate, if they're indicating that it's a mile away, I do think that's too close, but I don't know where else. I mean, in certain respects, you're right that he's going to be near a school regardless, but that's one of the reasons I think home confinement is even more important in terms of that. Since he's not employed, he's only to leave to come up for court appearances here. All right. Otherwise, he is not to leave his home. And
Your Honor, my client is fine with that.
and while, so in the way I'm going to word it at this point, I'm going to take a look, Google's look, and I may change it in some other way, but right now you're not to appear within 2,000 feet of any school or educational institution. You understand that, sir?
Yes, Your Honor.
And my understanding is that there are no children at that address.
There are no children. It is the brother in blue who lives there.
Gotcha. Okay. There already is a provision, I think, and I'm just going to now have to double check this. actually don't have that provision. But somebody's going to have a long conversation. I'm going to indicate there is to be no contact with any individual under the age of 18. You understand that, sir?
Yes, Your Honor.
We have the two individuals of no contact. I have minor school, mother's place of work, libraries. They already have actually a provision that can't go to libraries, schools, or any place where minor children may be present. I do have that, but I don't have the specific. All right. So that's what we will do. So you need to report before you leave the state. You have to be on that tether. It has to be a home confinement tether. They'll make sure that you have the opportunity to get down to that location.
Today, sir.
You're not going to be able to do it today because it's going to be too late.
First thing in the morning?
It has to be first thing in the morning.
No problem.
All right. And then I think the address is in the motion so that the people have what address he's supposed to be tethered to.
Yes, Your Honor.
And
But if needed, I'll email it again. If needed, I'll send it.
Okay. And I'll just make sure my order contains that particular address.
Thank you so much, Your Honor.
Thank you.
All right. Thank you.
What we've just witnessed is a classic example of how complicated pretrial decisions can be in serious criminal cases. The court wasn't deciding guilt or innocence today. That will come later in the trial process. Instead, the judge had to determine how to manage the defendant's release conditions in a way that protects the community while still respecting the legal principle that every person is presumed innocent until proven guilty. The final decision creates a structured compromise. The defendant is allowed to relocate to Ohio with family, but only under strict home confinement tether monitoring. He cannot leave the residence except for court appearances. He must stay away from schools and minors, and he must comply with multiple no-contact orders designed to protect potential victims. These conditions reflect the court's attempt to manage risk without immediately placing the defendant back in custody. It's a reminder that the justice system often operates in gray areas, weighing competing concerns like safety, fairness, and constitutional rights. But now the story continues beyond this hearing. The real questions, the allegations themselves, the evidence, and the credibility of everyone involved will ultimately be decided during trial proceedings. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.